Performance of reciprocal promise. The law on the subject is contained in sections 51 to 58. Reciprocal promises may have to be performed simultaneously, or one after the other. Such promises constitute concurrent conditions, and the performance of one of the promises is conditional on the performance of the other. If one of the promises is not performed, the other two need not be performed. Performance of reciprocal promise. Promiser not bound to perform, unless reciprocal promise ready and willing to perform. When a contract consists of reciprocal promises to be simultaneously performed, no promiser need to perform his promise unless the promisee is ready and willing to perform his reciprocal promise. Order of performance of reciprocal promises. When the order of performance of the reciprocal promises is expressly fixed by the contract, they shall be performed in that order, and where the order is not expressly fixed by the contract, they shall be performed in that order which the nature of the transaction requires. Liability of party preventing event on which the contract is to take effect. When a contract contains reciprocal promises, and one party to the contract prevents the other from performing his promise, the contract becomes voidable at the option of the party so prevented, and he is entitled to compensation from the other party for any loss he may sustain in consequence of the non-performance of the contract. Performance of reciprocal promise. Effect of default as to that promise which should be first performed, in contract consisting of reciprocal promises. When a contract consists of reciprocal promises, such that one of them cannot be performed, or that its performance cannot be claimed till the other has been performed, and the promiser of the promise last mentioned fails to perform it, such promiser cannot claim the performance of the reciprocal promise. Effects of failure to perform at a time fixed in a contract in which time is essential. When a party to a contract promises to do certain thing at or before the specified time, and fails to do any such thing at or before the specified time, the contract, or so much of it as has not been performed, becomes voidable at the option of the promisee, if the intention of the parties was that time should be of essence of the contract. Effect of such failure when time is not essential. If it was not the intention of the parties that time should be of essence of the contract does not become voidable by the failure to do such thing at or before the specified time, but the promisee is entitled to compensation from the promiser for any loss occasioned to him by such failure. Performance of reciprocal promise. Effect of acceptance of performance at time other than agreed upon. In case of a contract voidable on account of the promiser's failure to perform his promise at the time agreed, the promisee accepts performance of such promise at any time other than agreed. The promisee cannot claim compensation for any loss occasioned by the non-performance of the promise at the time agreed. Contract cannot be avoided where time is not essential. Where time is not essential, the contract cannot be avoided on the ground that the time for performance has expired. There the promisee is only entitled to compensation from the promiser for any loss caused by the delay. Effect of acceptance of performance out of time. Even where time is essential, the promisee may waive his right to repudiate the contract, when the promiser fails to perform the promise within the stipulated time. In that case, he may accept performance at any time other than that agreed. Performance of reciprocal promise. Contract to do act afterwards becoming impossible or unlawful. A contract to do an act which, after the contract is made, becomes impossible, or, by reason of some event which the promiser could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. Compensation for loss through non-performance of act known to be impossible or unlawful. Where one person has promised to do something which he knew, or, with reasonable diligence, might have known, and which the promisee did not know, to be impossible or unlawful, such promiser must make compensation to such promisee for any loss which such promisee sustains through the non-performance of the promise. Reciprocal promise to do certain things that are legal, and also some other things that are illegal. Where persons reciprocally promise, first to do certain things which are legal and secondly, under specified circumstances, to do certain other things which are illegal, the first set of promises is a valid contract, but the second is a void agreement. Alternative promise, one branch being illegal. The law on this point is contained in section 58, which says that, in the case of the alternative promise, one branch of which is legal and the other illegal, the legal branch alone can be enforced. Impossibility of performance. Initial impossibility. When the parties agree upon doing of something which is obviously impossible in itself, the agreement would be void. Impossible in itself means impossible in the nature of things. The fact of impossibility may be and may not be known to the parties. If known to the parties, it would be observed that an agreement constituted, quite unknown to the parties, may be impossible of being performed and hence void. If unknown to the parties, where both the promiser and the promisee are ignorant of the impossibility of performance, the contract is void. if known to the promiser only. Where, at the time of entering into a contract, the promiser alone knows about the impossibility of performance, or even if he does not know, though he should have known it with reasonable diligence, the promisee is entitled to claim compensation for any loss he suffered on account of non-performance. Subsequent or supervening impossibility. When performance of promise become impossible or illegal by occurrence of an unexpected event or a change of circumstances beyond the contemplation of parties, the contract becomes void. Appropriation of payments. Application of payment where debt to be discharged is indicated. Where a debtor, owing several distinct debts to one person, makes a payment to him either with express intimation or under circumstances implying that the payment is to be applied to the discharge of some particular debt, the payment, if accepted, must be applied accordingly. Application of payment where debt to be discharged is not indicated. Where the debtor has omitted to intimate and there are no other circumstances indicating to which debt the payment is to be applied, the creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor, where its recovery is or is not barred by the law in force for the time being as to the limitation of suits. Application of payment where neither party appropriates. Where neither party makes any appropriation, the payment shall be applied in discharge of the debts in order of time, whether they are or are not barred by the law in force for the time being as to the limitation of suits. If the debts are of equal standing, the payments shall be applied in discharge of each proportionately.